Hello, I'm David Pollard.
And I'm Tom Robinson.
And we're here to talk about insolvency practitioners, IPs, and the new pensions notification obligations in relation to occupational pension schemes, which is clearly a huge issue that's coming up under the Pension Schemes Act 2021. This is a warning webcast intended for professionals going forward. Tom is going to look at the current law, the current position mainly, and I'm going to look at some of the changes that are anticipated coming in under the new 2021 Act, probably from April next year.
So current situation and changes that are already in force. Think of me as the voice of authority. David is the voice of wild speculation as to what's about to happen. So currently, we've got sort of 5 categories, 5 obligations I want to just talk about. Before we get to the notifiable event regime, there are the 4 to look at. Ones that are triggered by the regulator or by someone learning of a breach of the law. So section 72, that allows the regulator to send a notice, which can be direct to an IP, if he's a person who appears to hold information relevant to the regulator's functions. And the regulator's notice will require documents or information to be given. It's an offence not to comply without a reasonable excuse. Confidentiality of the material is not a reasonable excuse. There's some case law on that from the Nortel case. Privileged material is carved out. And then the other section here, section 70, where a professional advisor in relation to a scheme has reasonable cause to believe there's a breach of the law, they need to report that to the regulator. So section 72 and section 70. Then, David, tell me about IP obligations when they're appointed.
Well, there are existing obligations in the 95 Act and the 2004 Act, specifically on insolvency practitioners, to note if they're appointed in relation to an employer of an eligible scheme, or actually any scheme, then they have to tell the regulator and the PPF and the trustees of their appointments. It applies to money purchase schemes seemingly as well as final salary schemes that are eligible to PPF. That's section 120. And then as the insolvency progresses and the scheme tries to work out what's going on, there's a scheme status decision notice obligation. Is there a scheme rescue and it rescued the employer, or is there not going to be a scheme rescue? These are all really relevant in relation to the PPF going forward. So those obligations are there in existence at the moment.
So that leaves the notifiable event regime, and this is something that came in under the 2004 Act. There's been a recent change to it, which is to increase the fine for not complying with it. So notifiable event regime imposes obligations on certain people to notify the regulator of certain events. The change that happened under the 2021 Pension Schemes Act was to increase the maximum fine up to £1 million. So this is important stuff. It's under section 69 and some 2005 regulations, although as David will explain, there's potential change, or there is change coming. What about the current position? Well, first point is we're looking at schemes that are eligible for PPF entry. So these are notifiable events about the sorts of support that an employer can give to a scheme that could end up in the PPF, not a money purchase scheme, not a personal pension scheme. Second point to make is that the obligation falls on, and we're talking about 2 categories of events here. One is ones concerning the scheme, the other is ones concerning the employer. But because we're looking at IPs for this webcast, just on the employer side, the obligation falls on the employer to notify, but the penalty can fall on others. So for example, if the failure to notify was due to the consent or done with the consent or connivance of a director, then the penalty could fall on the director. Because this is a talk about IPs, could IPs fall within this category? Well, the definition or the category of people who might be caught by the fine are directors, managers, secretaries, or other similar officer of the body, or a person purporting to act in such a capacity. We know from Schedule B1, Para 1, that an administrator is appointed to manage, among other things, the affairs of the company. We know he acts as an agent of the company. So moot point, really, whether you might find an IP falling within this category. And if so, and if the failure to notify is done with his consent or connivance, or her consent or connivance, then theoretically the fine could fall on them. What events are we actually talking about? It's the sort of red flags you'd expect for where an employer is unable to support a pension scheme, or that amount of support is going down. So things like reducing the credit rating, things like not trading in the UK or ceasing trading in the UK, things like breach of a banking covenant. That was the case and is the case at the moment. But David, over to you as to what might change in light of the recent consultation.
Yeah. So the new 2021 Act, Pension Schemes Act 2021, has an expanded role for these notifiable events obligations. So Section 69 already enforces the expansion of the fine for default by the employer, an obligation on the employer, from the £50,000 maximum to the new £1 million maximum, which could then look through to insolvency practitioners. Slight change in that no longer applies in neglect. That's been dropped or something like that. But alongside that, we've got a new notifiable event obligation, sort of super notifiable events, Section 69A. This is not yet enforced. This is what the government is consulting about in September. About a new series of events that need to be notified, and the changes there that are they're sort of super events: cessation of control of an employer, major disposal of assets, grant of major security. Those are events that are notifiable under the new superpowers under Section 69A. You have to copy this notification. It's not just to the regulator, it's got to be copied to the trustees as well. So you have to tell the trustees, don't have to do that in relation to Section 69 events. There needs to be a written statement accompanying the notification explaining what's going to happen in relation to the pension scheme. And these notices need to be updated as matters progress or change or stop. So if there's whether you need to do this weekly or monthly or as things are negotiated, we're not yet clear on that. Again, a maximum penalty of the new £1 million penalty if you fail. And again, that looks through potentially, so if an employer fails to comply, that could look through to officers, managers, directors, etc. The other big change is that this obligation isn't just on the employer. It's on the employer and on everyone associated or connected with the employer. So it could include directors of the employer, employees of the employer, other companies in the same group as the employer. They could all be now subject to this super Section 69A obligation with the potential for the £1 million penalty if they fail to comply. And finally, it's not really clear whether if there's an insolvency practitioner, say, appointed over a parent company of an employer, not appointed in relation to an employer, does that mean the parent company has ceased to have control of the employer? Notoriously difficult definition of control in Section 435. I've written a whole book on that. But it could mean that actually an insolvency practitioner appointed over a parent or a 33% shareholder or something like that could have a notifiable event obligation under 69A as well. So where are we, Tom?
Well, I mean, I think it's always been pretty messy, this area, or at least quite difficult to get right. One of the changes I found most interesting is that what triggers the new obligation or new event seems to be a decision in principle to do something. So when is the decision in principle taken? And the current draft regulations talk about decisions in principle being decisions taken before you start negotiating with third parties. So we'll need to watch this space very much as to when that happens and from an IP's perspective, what to do to ensure we're the right side of a £1 million fine. So watch this space, everyone.
I suppose the obligation could arise in relation to an IP selling the business. So an IP is appointed over an employer and then decides to sell the business, could be a pre-back or just a business sale. That's going to trigger the obligation, even though the scheme might be in an assessment period and you sort of think, what's the point? But that's going to trigger potentially a Section 69A obligation under the regulations. We have to wait and see what the regulations say.
Yeah.
So slides are available with lots of cross-references. See the link up there or down there or somewhere like that.
There'll be a link somewhere on the caption to check the slides. Good, thank you.
Good.